Hi everyone, my name is Lizzie Chan, and I'm a member of the CPR Institute's Young Leaders in Alternative Dispute Resolution Steering Committee. I am delighted to host today's episode of the CPR Y-ADR Corporate Counsel interview series. Y-ADR seeks to educate the next generation of leaders on the full spectrum of dispute prevention and resolution techniques, and to provide an insider's view into how CPR's community of internal counsel, external counsel, experts, academics, and other practitioners in the ADR field are using these techniques to manage conflict to enable purpose. As part of this goal, I'm hosting the CPR Y-ADR Corporate Counsel series to speak with in-house counsel and ombuds in companies and organizations all around the world about their experience with ADR, and also to share their career advice for young practitioners in the field. Today, I am delighted to welcome Müge Anber-Kontakis, who is Vice President, Global FD&D Manager and Counsel of the American Steamship Owners Mutual Protection and Indemnity Association Incorporated, or the American P&I Club, based here in New York. Hi, Müge, we're delighted to have you here today.
Hello, Lizzie. Thank you very much for having me.
Well, my first question for you is, can you tell us about your educational background and how you became interested in the maritime industry?
Sure. Let me start from my background on how I got into the maritime industry. I grew up in Turkey at a port town called Iskenderun. So maritime is in my blood, and I was seeing vessels on the water all the time, and I had some families in business and lots of friends with their families in this business. That's how I got in the maritime. I was always interested in it, and I went to law school in Istanbul and practiced law there before coming to New York. I came to New York in 2003 to get my degree at SUNY Maritime College on a master's degree on the International Transportation Management, where I also attained graduate certificate in charter and operations. And after that, I got my LLM degree from Hofstra Law School here in New York. And meantime, I worked as a lawyer here. I practiced law here in New York too, before joining the American Club.
Thank you so much for that introduction to your educational background. I'm glad to hear that you grew up in a port town, because I'm actually interviewing you from Hong Kong, also awesome. An important place for maritime work. My next question for you is, what did you do with the education that you had gained in the maritime industry? So can you tell us a little bit about your career background and also your current role at the American Club and the types of disputes that you're involved in?
Sure. I practiced law at prominent maritime law firms in Istanbul and New York. That was before I joined the American Club. And for the past 15 years, I've been with Ship Owners Claims Bureau, who are the managers of the American Club, providing marine insurance to the ship owners and charters. As part of the American Club's claims department, I handle a variety of both P&I and FD&D claim matters worldwide, and I'm going to expand this a little bit for the audience's understanding. P&I stands for Protection and Indemnity Insurance, that provides cover to ship owners, operators, and charters for third-party liabilities encountered in the commercial operation of the insured vessels. While FD&D stands for Freight, Demurrage, and Defense, also shortened as Defense Insurance. And this is the legal costs insurance that covers expenses in the handling of a wide range of disputes of maritime nature that are not covered under the P&I. So the claims I handled include like charter party disputes, cargo claims, disputes under shipbuilding and repair contracts, or ship sale and purchase contracts, casualties such as collision and grounding of the vessels, ship-emanated pollutions, marine insurance contracts, disputes, and etc. Additionally, being the global FD&D manager, I oversee handling of the FD&D claims globally, and I've been the FD&D manager for the past 8 years. And we handle and resolve many of the claims in-house while we retain outside lawyers when necessary, depending on the size, complexity, jurisdiction of the disputed issue, and where the claim involves litigation and arbitration. I am also an arbitrator as of 2020, affiliated with the Society of Maritime Arbitrators of New York. And since 1979, I'm the second female SMA arbitrator who is not of North American origin. So that's something I noticed actually very recently. And I'm also an officer of the Maritime and Transport Law Committee of the International Bar Association for the past 4 years.
Müge, you're a role model for so many of us. It's so interesting to learn more about the maritime industry. I can't say that I have done any maritime industry cases, but I know certainly that, like just reading the news, that shipping, like the demand for shipping services has actually increased, I think, during the pandemic. So it's a really exciting and dynamic industry to be in. I hope to have the opportunity to do more work in this area myself. One thing I wanted to mention is dispute prevention and conflict avoidance. This is a really important aspect of the CPR's work, and we actually have a pledge where we invite companies and law firms to take concrete steps to avoid disputes and to avoid conflicts. And why is that? We just think it's really important to allow companies to get on with what they're best at doing, which is the business itself. And that's why at the beginning of this interview, I mentioned that our goal is to help companies to manage conflict to enable purpose. Yeah. And on this theme, I was wondering if you could tell us what role you have in helping the American P&I Club to mitigate risk, to minimize risk exposure, and to avoid disputes.
Sure. As the American Club, we have a very proactive, very involved loss prevention work. We do have a loss prevention department. They're very knowledgeable, and they're always on top of the potential issues, potential risks our insureds, whom we call members, our members may face. And you can visit our website. We have posted lots of articles, videos focused on loss prevention, and from the claims view. And we regularly get contacted by our members when they have questions about their contracts. While they are negotiating contracts, we review those contracts, and we make comments, and if we notice any clauses that may likely raise risk for them throughout their operation, the vessel's operation under a certain contract. This could be charter party contract or MOAs, lots of bills of ladings, for example. We point out those risks and help them by redrafting the clauses, and some way helping them in their negotiations of their contracts. We regularly do that on a day-to-day basis.
You mentioned earlier in the interview that sometimes you make use of external counsel. So I was wondering, what do you look for when you're selecting external counsel to help you with the dispute?
Well, Lizzie, there are numerous factors we consider while selecting a counsel for the cases we handle. We look at the jurisdiction of the lawyer covers, obviously, and counsel's expertise, experience, and ability on the subject matter is important to look at. Having said that, a lawyer does not have to be the most experienced lawyer on the subject matter. Lawyers are educated and trained to do research, know what to look for and where to find the relevant or useful information. Essentially, a good lawyer, once gaining that relevant knowledge that would support his or her client's position, should properly apply the information to defend or prosecute a case for the client. So we look at that law, if that lawyer that we are going to go with has that ability on the case in front of us. We also look at the history of relationship, and I look at it for sure, the history of the relationship with my colleagues and or our association generally. Attitude matters. Look at, has the counsel showed a cordial or hostile behavior while representing the other side in the past cases? Has he or she been proven to be successful in the previous cases or given a good or bad advice? And obviously we look at the fee rates, and the overall estimated legal costs should justify the appointment of a specific lawyer. So if there are good alternatives, we generally do not go to the overly expensive lawyers. Also, depending on the complexity of the case, we monitor the size of the legal team we employ. Some non-complex cases can be handled by junior associates, but obviously under the supervision of their supervisor, the more experienced lawyers, while in some cases you need a team of associates and partners.
That is so interesting. I was particularly interested in your comment about how counsel have performed when they're the opposing party to you. So it's almost like you're always potentially looked at, observed by a potential
We keep an eye. We keep an eye on everybody.
Yeah, that's really interesting, and something definitely to bear in mind. So my next question for you is related to this question about hiring external counsel. So, how proactive are you in arbitral proceedings? I appreciate that this might, depend on the size and complexity of the case, but very generally speaking, how proactive would you say you are in arbitral proceedings?
Although we retain outside lawyers, we are still very involved and proactive in arbitral proceedings worldwide. This is our club-wide practice. I believe for an in-house lawyer to service the company in good quality, he or she must actively involved at every stage of the legal proceedings by staying in timely communication with the outside counsels and experts, reviewing and commenting on arbitration submissions, discussing the merits and strategy with the outside lawyer in as most knowledgeable way as possible. You basically got to put time and effort in a case throughout its life to help the outside counsel to achieve success on the case that he or she is handling for you.
That's so important, having that in-house counsel and external counsel collaboration. One thing I wanted to mention is a very interesting talk given by the recently elected ICC Court of Arbitration President Claudia Salomon, where she focused on the perspective of the user in the international arbitral process. And one of the things she mentioned is the evolving role of in-house counsel and how they often play very important, like C-suite level advisory work to the company. And she thinks, she suggested that, we need to think about the arbitral process and how we can actually involve in-house counsel more. So for example, maybe, as a matter of course, we should consider whether to include in-house counsel on communications from the tribunal. Maybe as a matter of routine, we should inquire whether the client actually wants to be represented at the case management conference. So I think your comments about being proactive in every step of the legal proceeding is consistent with that. My next question relates to something that you actually mentioned in the selection of counsel about looking at fee rates. So what are some best practices that you can recommend in managing costs? And what is your approach to budgeting for your disputes?
So I have noticed that legal costs increase, particularly in these situations during maritime case handling, where there is a vessel arrest, involvement of multiple jurisdictions, the opponent's tactics making the legal issues and procedures more complex, therefore requiring extra time of our appointed lawyers. Where there are arbitration or court hearings and witness or expert testimonies, and where there are complexities in enforcement procedures. For efficiently managing the legal costs, we regularly monitor our cost exposure. We endeavor obtaining realistic cost estimates from the lawyers before the start of the legal proceedings and during the legal proceedings as new submissions become required. By and large, I do focus on requisite submissions and supportable arguments that would strategically strengthen our position. Muddy in the waters or uncalculated kitchen sink approach is mainly not my style, as that indicates weakness and eventually increases cost without a probable benefit.
That's really good advice. During the pandemic, many of us have learned how to use Zoom, and it's been a pleasure to be able to meet other in-house counsel like yourselves through Zoom. And I mentioned this because now lawyers are using virtual platforms like Zoom to run entire arbitral proceedings. So I was wondering, what's been your experience with virtual hearings during this pandemic period?
I find that in several ways, virtual hearings are better than the usual process and equally effective. Globally, the arbitrators by now have perfected the technology, so the hearings go smoothly, right? Virtual hearings provide more scheduling options as the participants, such as parties' principals or the witnesses, do not need to travel overseas. Within the same day at different hours, I was able to attend hearings in multiple jurisdictions, and this is the most tremendous benefit of the virtual hearings for me, because earlier this year, in one day, in the morning, I was able to attend arbitration hearings in London, and in my afternoon in New York, I attended court hearings in the US, in Utah, and I still had dinner with my own family. Practically, I could squeeze in another hearing in Asia in my late evening. But on the other side, there are few cons. There is a risk that the parties may lose focus if they get sidetracked during the arbitration while taking it from home, right? Doorbell ringing, dogs barking, child walking in the room. Luckily, none of them has happened to me, but I know that it happened to some people. And there is also, as it happened, one team may mistakenly join into another party's breakout room. So this raises some level of mistrust to the process's confidentiality. Hence, in virtual hearings, managing the process with the breakout rooms is an additional and crucial task. And you won't be seeing the opponent's rolling eyes and sign during your expert's testimony or cross-examination. So the element of human natural reactions is eliminated in virtual hearings. But overall, I had very positive experience with virtual hearings, and I think it is a blessing for us that we all learned how to manage the virtual hearings and become a lot more efficient than the past, in my opinion.
Thank you so much for your really interesting observation. I love that you were able to attend a London arbitration in the morning, a US court proceeding in the afternoon, and still make it home. But then I think that that is so fantastic. And I think you make a good point, like the administrator becomes very important in a virtual hearing platform just to make sure that the right people are in the right rooms and you don't breach confidentiality that way. That's really important. I'd like to pivot now to the last segment of our interview, which is about your career advice for our listeners. So my first question here for you is, what's your advice for young practitioners who want to move in-house?
You know, Lizzie, when I first joined this Ship Owners Claims Bureau, after working for a maritime law firm in New York, one distinction was pointed out to me during my interview that at private practice, you handle, say, 10 to 20 concurrent cases, while at the club, you would handle up to 400 claim matters a year. As you know.
Wow.
So I don't have 400 claim matters, so I don't want to scare people. But so speaking from the perspective of a lawyer employed by a global marine insurer, my suggestion is being prepared to handle a range of legal issues affecting the company and oversee the cases that's been outsourced to lawyers at independent firms. A successful in-house lawyer candidate should have some knowledge of legal issues and risks involving the business of the organization where he or she targets to become in-house. Once you go in-house, you'll be seeing lots of new issues that you haven't come across before in your private practice. Also, my suggestion to young practitioner in-house lawyers is to know your company's business. Get accustomed to the culture with that aim. Once you become in-house, spend time and stay connected with the different departments to understand their role in the company. And don't hesitate to ask questions to your colleagues. And no one should be ashamed of not knowing something and asking questions. I think you get a lot more credit by inquiring what to do when you come across new issues. There's nothing wrong with that.
I think that's such an important point, knowing the client. One thing that's really come through in the interview series is the importance of reaching out to the client. And there's been a real encouragement from the in-house counsel people that I've interviewed that even, more junior practitioners should reach out to the client just for a coffee, just to get to know them. As an initial step towards better understanding the company. And of course, in-house counsel have a sort of bird's eye view or bird's eye perspective of the company in a way that practitioners might not have, because they're so focused on that specific case. But of course, what's really important, right, is that we understand that case in the context of the 400 or thousands of claims that your company faces. And it's so important to understand that in order to be an effective counsel in a specific matter. My last question for you is, what is your general advice for young practitioners in the ADR field?
Lawyers are target-oriented, right? We want successful results in our cases. Getting there and accomplishing a sustainable legal practice is a process which requires a high standard of quality in legal service. So these would be my suggestion to the young practitioners in the ADR field. Well, build up knowledge and improve skills by reading published arbitration awards on a variety of disputes that arose in your industry, and articles published in your area of practice. That will help you to stay current as well. Bearing in mind that an arbitrator's mindset would be shaped based on his or her experience, I encourage the young practitioners to know the arbitrator's background. That applies to selecting your own arbitrator and the other members of an established arbitration panel or tribunal. That would help you to understand how those arbitrators have approached several legal issues, reacted to some tactical strategies adopted by lawyers, and how they reached to decisions in their prior arbitrations. For that, reading their awards will be instrumental. Be accurate in your submissions. False or inconsistent assertions have certain a negative effect on credibility and would not look ethical. And remember, the devil is in the details, right? So pay attention to the details that may be buried in the documents and facts in front of you, as they may support a case you are prosecuting or defending for your client. I have seen, Lizzie, I have seen some lawyers not paying enough attention to details, and they're regretting that. And be observant and seek mentorship from the experienced colleagues or other lawyers in your industry. Throughout my career, I have been blessed by good mentors. My personal experience showed that people generally enjoy providing guidance to young practitioners who are receptive to mentoring. So allow those people to guide you. And last but not least, and I would like to emphasize this, is that intelligence with integrity will get you to success in your career while building up a respectable reputation, especially in the maritime industry, where at the global scale, people know each other and meet regularly. Any bad feedback from the clients or other legal practitioners spread quickly, and you don't want to start your career with negative feedback.
Thank you so
very
much. Thank you so much for your feedback, and I love that intelligence with integrity. That's something I will definitely take away. Well, thank you so much for taking the time to provide guidance to all of our listeners. We really appreciate it. And I thank our audience for tuning in.
Lizzie, thank you very much. My pleasure. I'm humbled to be here with you. Thank you.
Thank you again, Müge.